Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Dubin v. United States, which was argued before the court on February 27th. It's my honor to introduce our guest today, John Richter, who is a trial and investigations partner at King & Spalding. He previously served as the acting Assistant Attorney General in charge of the Criminal Division at the U.S. Department of Justice and as the U.S. Attorney for the Western District of Oklahoma. With that introduction, I'll hand things over to Mr. Richter.
So the court heard oral argument in the case of Dubin versus United States. This is a case involving a criminal statute, a federal criminal statute, Title 18 U.S.C. Section 1028, which provides for aggravated identity theft, a 2-year sentencing enhancement. And the statute defines aggravating identity theft as the knowing transfer, possession, or use without lawful authority of a means of identification of another person during and in relation to certain predicate offenses. And the certain predicate offenses are fraud, basically any fraud statute, a firearm statute, Title 18 U.S.C. Section 922A6, which relates to making false statements in connection with the acquisition of a firearm, and certain immigration, citizenship, and nationality type predicate offenses. The question presented for the court was whether a person commits aggravated identity theft anytime he uses someone else's name while committing the predicate offense. And in this case, the Dubin case involved the submission of a claim for reimbursement to the Centers for Medicaid and Medicare and Medicaid Services for a service that was not provided in the manner in which the claim claimed. In particular, the case of Dubin involved a psychologist in which the claim at issue that was submitted certified that the work for which the claim was being submitted for government payment was performed by a licensed psychologist when in fact it had been done by someone, not a psychologist. And as a result of which, the claim was deemed to be a false claim. The government brought a healthcare fraud offense, indicted him for healthcare fraud, and in addition, indicted him for aggravated identity theft. And he was convicted, and the conviction was upheld in the Fifth Circuit. The oral argument today was very interesting for a few reasons. First, the court, the petitioner, represented by Professor Jeff Fisher, basically argued that the Fifth Circuit's decision stretched the statute too far. He argued that Dubin had permission for the patient, so-called patient L's authority, to make use of his name, of that patient's name, in submitting a claim, and so that there was no actual misrepresentation or use of the name without lawful authority. Rather, there was simply, and so therefore the name and the use of the identity was only incidental to the commission of the offense. Basically, the argument that was made by the petitioner was that in the context of this particular statute, given that that there is a underlying predicate federal fraud offense in which the median sentence nationwide at this point in time for federal fraud offenses is about 12 months, and that about 12% of all convicted offenders for federal fraud offenses receive probation, that the transformation through the construction of this interpretation of this statute as argued by the government in this appeal would transform every fraud prosecution into an aggravated identity theft prosecution, thereby meaning that every single fraud prosecution that would have the opportunity for a 2-year mandatory minimum sentence, which applies to aggravated identity theft, as compared to, say, wire fraud, healthcare fraud, mail fraud, bank fraud, where it's a range, but there is no mandatory minimum sentence. The court was very active in its questions. I think the challenge for all the justices was the interpretation of the language of the aggravated identity theft statute, which is far from the clear. It uses phraseology that is pretty broad in nature. Justice Thomas led the questioning. Obviously, Justice Thomas, who has become much more active on the bench than historically he was in terms of asking questions. And he led off by asking whether Mr. Dubin, the defendant in this case, was authorized to use patient L's identity, to which petitioner's counsel said, yes, he was authorized to use for the transaction. The only problem was that the underlying services were provided. They just were not provided by the licensed psychologist. They were provided by another lesser licensed practitioner. Justice Thomas used an analogy of, well, wait a minute, if I drop off my Porsche, he was clear then to make sure that he doesn't actually have a Porsche. When I drop it off at valet, I drop it off and give them general authority to move my car, but they're not authorized to drive it around town. And so then there was some back and forth about that. Justice Jackson then wanted to pursue a hypothetical about a waiter in which a waiter is given a credit card, and instead of just the food that was ordered by the patron, the waiter then charges additional things on the card. Interestingly enough, I would have thought that in that instance, the analogy would have been that the petitioner's counsel would have said that was not lawfully authorized, and then therefore was without lawful authority. But he would have instead he seemed to concede that in fact that analogy would be actionable under the aggravated identity theft. Justice Sotomayor pursued another analogy involving the waiter, in this case a tomahawk steak rather than a sirloin steak. Point being is they went back and forth with the justices using a lot of hypotheticals that had little to do with the actual facts of the case involving Mr. Dubin. Justice Sotomayor also then posed a couple of another hypothetical about, well, what if instead of a claim for psychological services as here, it was a claim for, say, cancer services? Why would that be outside the lawful authority, notwithstanding that it was a patient? Again, the petitioner's counsel answered that he believed that that individual could be prosecuted for fraud, but potentially not for aggravated identity theft. There was then some additional argument on a number of other cases. Justice Kagan raised questions about the use of and how this might apply to state fraud statutes, and underline since fraud is defined as predicate in 1028 is not limited just to federal fraud. And there was back and forth on this in relation to language, and whether that meant instrumental or incidental. They then had some back and forth during their argument about whether the caption, which is named, it lists aggravated identity theft as the caption, what effect such a caption might have. And I think the Petitioner's Counsel handled that fairly adeptly by saying that the caption certainly can have some influence, but that you didn't have to rely on the caption to reach a conclusion consistent with the petitioner's position. That really the conduct by Dubin is at the heartland of what Congress intended for healthcare fraud, but not for obviously aggravated identity theft. One of the key points that the Petitioner's Counsel made a number of times is how the application of a 2-year mandatory minimum to every federal fraud case would change drastically the plea bargaining position and leverage in fraud cases, and therefore the fact that this couldn't have been what Congress intended in passing this statute. There was back and forth between the meaning of the broader portion of the statute that deals with identity theft, which is basically knowingly possessing or used in connection with unlawful activity, and does not carry a 2-year mandatory minimum, with the subpart that involves aggravated identity theft. The justices went back and forth on whether this aggravated identity theft is essentially a subset of the broader identity theft statute, or whether it essentially is an enhancement. And what the petitioner was arguing is that he didn't think Congress would have wanted to transfer every fraud case to a mandatory minimum. And there was a lot of discussion about a case called United States versus Michael, in which Judge Jeffrey Sutton out of the Sixth Circuit sought to define in his mind how this statute should be interpreted. That if you lie about who received the services, then that would fall within the aggravated identity theft statute. If, however, you lie about when or what or how the services were rendered, under Judge Sutton's formulation, following Sixth Circuit jurisprudence, this statute would not apply in the case of Dubin, where services were provided. It was an actual patient of the psychologist, but the psychologist did not provide the services. There was a question by Chief Justice Roberts about whether the fact that there had been, what if this was overbilling for, say, 3 hours and the patient had theoretically, say, 8 hours of insurance coverage? Was the deprivation of that extra, that loss of that time material to interpreting this statute? The Petitioner's Counsel handled that by basically saying that all fraud obviously involves potential harm, but that the harm isn't textually based, and therefore really is not for consideration. In terms of there was then a lot of back and forth about the way in which the statute ought to be interpreted. What I think stood out in this case was how each of the justices came at different ways of interpretation in seeking to question counsel as to how they ought to read the statute. And I think, and what seemed very clear is that each of the justices were thinking about this case and interpretation principles, not just for this case, but also for how such interpretation principles might set a precedent for use in other cases that will be coming down the road. So, for example, they talked about vagueness, they talked about the rule of lenity, they talked about constitutional avoidance, and then obviously they talked about various other statutory construction and interpretation principles that they thought ought to be one or more of the ways in which they could interpret this statute. I did learn a new rule of construction and just some legal Latin, e justem generis rule, which is a rule of construction that follows specific words or general words in a statute that follows specific words in a list must be construed as referring only the types of things identified by the specific words. Justice Coney Barrett raised the question as to whether that principle applied, and there was some back and forth about that. I think ultimately there seemed to be, and then Justice Gorsuch very much got into and raised questions and concerns about federalism, and the concern that by applying this literally to every fraud case, it would swallow up essentially every state fraud case, and use the analogy that if he goes and orders salmon and was told that it was fresh when he was at the restaurant, and in fact it was actually frozen, that this in theory could be deemed to be fraud, and because they used the name of the person in charging the credit card, this could deem to trigger a aggravated identity theft conviction and a 2-year mandatory minimum. Obviously, he was concerned that all state misrepresentations would become federal offenses. So the back and forth between the justices, I think, was very interesting in that regard. And I think for the most part, the justices seem to be leaning, a majority of them, in the direction of trying to find a way to reverse the Fifth Circuit in the questioning of the petitioner's counsel, and seemed fairly supportive of him during most of the argument. They were talking about the title, they were talking about the rule of lenity, they were talking about statutory constructions and canons, and they were talking about constitutional avoidance and federalism. The response by the Department of Justice, I think, in contrast, the justices gave the Solicitor General's office a fair bit of trouble during the oral argument. The lawyer for the Department of Justice argued, talked about the waiter example, and acknowledged that he appreciated that this particular case was unattractive, given that the underlying healthcare fraud that was subject to in which the aggravated identity theft conviction applied was one claim for $338, and that it was a small fraud. But he tried to make the argument that, well, you still have to prove scienter, you have to prove the knowing intent, you have to prove it beyond a reasonable doubt. Gorsuch certainly popped in and said that anytime anyone overbills, it would violate the statute under that instruction. and again reinforce the federalism and does this really give fair notice to persons that they're violating federal law. The justices again repeated as they went and questioned counsel for the government about how their rules of interpretation might apply. Gorsuch emphasizing the federalism problem. There was a funny exchange in which they asked him whether it would apply, and he said, well, it would because interstate commerce applied. The Department of Justice's attorney seemed to be, acknowledge the breadth of the Commerce Clause jurisprudence at the Supreme Court level and the federal level, but seemed to be blaming the Supreme Court for it, which certainly got some laughs and wry smiles from the court. But Justice Gorsuch obviously was very concerned about notice and federalism. Justice Coney Barrett was very concerned about a due process because of the mandatory minimum. She saw this as a more serious offense, and yet it didn't seem that there was more egregious conduct. And here, of course, with Mr. Dubin, it was only $338 of alleged fraud that constituted the healthcare fraud conviction that was the predicate offense for a 2-year mandatory minimum. As you know, Justice Coney Barrett acknowledged to made the point that in response to some earlier questioning by Justice Thomas, the government's counsel acknowledged this was teeny fraud, which I think is a very technical way to describe this matter. But to the credit of counsel for the department, and notwithstanding the pressure he was putting on, he did his best to push back. I think at the end of the day, both Justice Sotomayor, Justice Kavanaugh, Justice Coney Barrett pressed, and Justice Gorsuch pressed him all very, very hard. Justice Gorsuch finally boxed government's counsel in and said, well, if the court were to reject the government's theory, what kind of fallback rule would the government support? In this case, the government's counsel urged that they adopt the Sixth Circuit reasoning, most recently as described by Judge Sutton, and that said that this Sutton test, which really turns on the distinction between if the name was about who received the service was instrumental to the crime, then it would qualify for aggravated identity theft using the name. If, on the other hand, it was simply the use of the name incidental to a fraud about how or when the fraud was the claim was the work for the claim was done, then it would not qualify for aggravated identity theft. There was a lot of, again, some back and forth by both Justice Coney Barrett and by Justice Jackson, who were very concerned about the implications of this 2-year mandatory minimum in what are effectively potentially cases that would not be so serious. And likewise, Justice Kavanaugh weighed in with regard to Judge Costa's opinion in the underlying Fifth Circuit case that courts should not assign breathtaking scope where a narrower interpretation is possible. Justice Kavanaugh was asking government's counsel about fair notice, about not entrapping the unwary, and asked why this case shouldn't fall in that jurisprudence. Government's counsel sought to make a distinction that said, well, unlike other cases This involves a predicate crime that's already defined and routine conduct. In other cases, it was just routine conduct by itself without a predicate. I think that was interesting, except that, of course, to the degree that, you fold the aggravated identity theft into basically every fraud case nationwide, it sort of collapses and makes every fraud case a 2-year mandatory minimum at the federal level. And that seemed to be what the panel the court was concerned about. Following government's counsel, petitioner's counsel had an opportunity for rebuttal, and he emphasized the in relation to aspects of the offense, and urged the adoption of Judge Sutton's approach, and basically saying that if it's a lie about the nature of the claim and not about who received it, then it's not a violation of this aggravated identity theft statute. And with regard to with lawful authority, again, it was designed to basically say it's got to be a set of circumstances in which essentially the name has been taken from somebody without their permission. In terms of the back and forth here, I think he finally closed with the real world consequences that he believes that petitioner's counsel believed would apply here, and that was that every simple fraud case would obviously be charged with aggravated identity theft, or at least at a minimum there would be the threat of it. That would change, obviously, plea bargaining, gain quicker pleas in federal fraud cases, that it would be an extraordinarily strong remedy that was not intended by Congress at the time that this statute was passed. The matter was then submitted for consideration, and obviously we would now the court will be meeting and determining who will write the opinion and the various positions that each of the justices will take. I think from reading the tea leaves, I think the majority of the justices, certainly a majority of the justices, were interested in reversing the Fifth Circuit and finding a way to narrow the application of the aggravated identity theft federal statute. But each of them, I think, was struggling with the proper means to effectuate that end. And I think what rule of interpretation should be applied in the circumstances, all mindful that whatever rule got applied here might very well then be used as precedent to apply in another situation, in another case with other circumstances where the application of that rule might effectuate an end that the particular justice would prefer not to see, or might prefer to see, depending on the nature. So, an interesting and lively oral argument today in Dubin versus the United States. I think government counsel had an uphill battle going into this, knowing that the court had taken it on a Fifth Circuit from the Fifth Circuit on cert, and it played out that way. Petitioner's counsel clearly had the easier, the more friendly bench today. But I think the struggle will be in writing the opinion, and the struggle will be in the breadth, ultimately, of what the opinion decides, as opposed and whether in fact they decide that they want a fairly narrow interpretation in their holding, and a remand to the lower courts to further develop and construe the case law as it may apply to other fact patterns that may come before the courts.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers. founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.